Hello and welcome to the classroom on POV Nigeria. In this class, we talk politics and socio-economic matters as they happen in Nigeria. My name is Henry, your professor in practice. Please, if you've not subscribed to our YouTube page, do well right now to go subscribe on at POV Nigeria. Remember to press the notification bell so you will be the first to be notified whenever we drop our content. Don't go anywhere. The classroom continues. See you.
The classroom.
You're welcome back to the classroom, and today let's talk about Nnamdi Kanu's rebuttal, his refusal to go for defense, especially against his prosecutor. Now, why do you think Nnamdi Kanu has decided not to go on a defense? And that is what we would be talking about today. But just before we get into talking about that, to refresh our minds in this class, why did Nnamdi Kanu even get to where he is in the first place? Remember, just a couple of weeks back, hell went loose when it was declared that Nnamdi Kanu has sacked his legal team as led by Chief Kanu Agabi, SAN, former Attorney General of Nigeria. And when that happened, people were, of course, asking how would he now go ahead with his case. He said he was going to, defend himself by himself. Remember, Nnamdi Kanu is not a lawyer and had not had the opportunity of ever defending anyone or himself, but of course this is first time of doing that. Now let's get into the legal context, the legal understanding of some of this things. But just before we get into that, it's very important that we understand the charges against him. Remember, the federal government, which we would call the FG, right now has labeled a 7-count charge, a 7-count terror charge, charge or charges against Mazi Nnamdi Kanu MNK, right? So the federal government has 7-count charges of terrorism against him, and Nnamdi Kanu felt that his team, that the legal team weren't doing enough, and therefore he decided to defend himself. Now let's get into the legal implication and context to some of the things that are happening. Now, according to the Nigerian criminal law, especially as outlined in the Administration of Criminal Justice Act, ACJA 2015, which absolutely stated that a defense, right, has the right to remain silent. A defendant has the right to remain silent and therefore equally has no reason whatsoever to provide evidence to anything that he says. Now, there's a caveat in some of these things. Now, just before we get into that, let's even write down what it is here. Now, Nnamdi Kanu is the defendant. He is the defendant. While the federal government are the prosecutors, the FG, okay, which is FG here, the prosecutors here in this case. They're the prosecutors in this case. So what the Administration of Criminal Justice Act is saying, that the defendant has the right to remain silent, right? He has the right to remain silent, which means Nnamdi Kanu has the right to remain silent and not even go forward to bring in defense. But remember, just before that, last week, Nnamdi Kanu had said that he was going to defend his case, and in doing that, he would ask that the court should summon about 170 something or 73 people, including Sonwolu, yes, Wike, what's the name of the governor of Imo State, Hope Uzodinma, and lots of other people that were the witnesses that would, of course, appear in that particular case. But he now, turned back to say he wasn't going to have all of those people, and he was not going to even defend the case on the other way around. Now, coming from the Criminal Law and Administration of Criminal Justice Act 2015, which of course I did say, says that Nnamdi Kanu has the right, all right, to be silent in that particular case. But there's a caveat there. The caveat says that if the prosecutor, that is the federal government, if the federal government closes the case, that the court will now look at a prima facie case on that particular matter to pass its judgment. The prima facie means that the federal government will look at the evidence that the prosecutor, the federal government, is bringing. The court will look at the evidence of terror against Nnamdi Kanu that was provided to it, and upon that, the court would make its judgment and either say Nnamdi Kanu is guilty because of course he has refused to go on defense on that particular case. But let's take a look at Nnamdi Kanu's role in his refusal to defend himself. What role is he trying to set there? Now, one of the roles he's trying to set is the low role of legitimacy. Now, that's one of the things he's trying to set there. Legitimacy, which means that he's trying to state here that he is believing that the whole case against him is a charade. The whole case against him didn't even work in the first place. It was prima facie. It wasn't even supposed to be there. So he's questioning the legitimacy of what the prosecutor is bringing against him. Then secondly, he's equally trying to tell the court, why not let's take a look at this case from the beginning so that you people can judge me fairly the way it should be done. But there are pros and cons of Nnamdi Kanu's refusal to go for the defense. Now, one of the pros, right, is that he is at this point, trying to realign the minds of the court to believe that there was no case at all against him, right? That everything that was against him were all flawed, and therefore there were no case against him. Now, that's one of the first advantages. Number one advantage of Nnamdi Kanu is that there is no prima facie, right? There's no prima facie against him, which means the federal government has no case against him. Right, so these are one of the advantages that Nnamdi Kanu is building on for not defending himself. But the big question is, will these hold waters at the end of the day? Would these hold water? Because what that means is the disadvantage of Nnamdi Kanu not defending himself, and on the other way around, is that the court would now agree with the little evidence as provided by the prosecutor, which is the federal government, that what the federal government is saying, in a sense, is right. Which means that the 7-count charge against Nnamdi Kanu are real. And upon this prima facie of the 7 counts charge against Nnamdi Kanu, they would make their judgment. So lots of people are asking, does it mean that Nnamdi Kanu has, of course, allowed himself to, okay, let the court just do whatever it is that they want to do? After all, he has served close to about 4 years in detention, and if he is given maybe 8 years or 10 years, he would have served like 5 years, and it's just remaining 5 years. Is he building, his case on that particular premise? Now, lots of people, of course, are discussing that and asking if that could be a method that he is using, to go against his prosecutors. But of course, that's all we have in our class today. And my assignment today is, do you think that the move by Nnamdi Kanu is a good one for not going against his prosecutor, for not going forward with the defense, despite the fact that he has asked that the court should summon some witnesses? You can drop your comment on the comment section, drop your answers, that is, on the comment section, and I will be there to mark and, of course, grade you at the end of the day. So please do well, if you must pass this course, do well to follow us on our social media platforms at POV Nigeria. Press the notification bell, and of course, that is the first step in passing this course in my class. My name is Henry, your professor in practice. I'll see you next time on my classroom, POV Nigeria. Don't go anywhere. Bye-bye.
The classroom.